The essential question that was being raised by Dr. Allam was that when he was given a notice to file a tax return for these years, I think it was 2011-12 and 2012-13, he was given, like everyone else is given at this stage, an automated notice to file a tax return. Now, it purported to be under Section 8 of the TMA, but Section 8 of the TMA requires notices to file a tax return to be issued by an officer. And if a machine has done it without the involvement of an officer, then it's not a Section 8 notice. Now, if it's not a Section 8 notice, then any return actually submitted is what is generally known as a voluntary tax return. And if it's a voluntary tax return, it's one which has no status, or certainly had no status until 2019. And if it had no status, you could not have an inquiry into it. And if you could not have an inquiry into it, the revenue couldn't challenge any position taken by the taxpayer by reason of an amendment via a closure notice. The only remedy the revenue could have is to issue a discovery assessment, but by which time the revenue would be far too late because of the number of years that have passed. So the question was this an invalid notice? Now, in 2019, Parliament passed legislation that was effectively saying the revenue has got this all wrong. They have been potentially issuing notices automatically without the statutory basis for doing so, because the statute, as I said, requires an officer to be involved. Now, there was another case which went to the upper tribunal called Rogers and Shaw, two different taxpayers who appealed against penalties for non-filing their tax returns. And the argument that had won them in the first tier tribunal was the revenue hadn't shown that these notices were issued by an officer. And if they hadn't been issued by an officer, they were not valid notices, and therefore a taxpayer couldn't be obliged to comply with them. Now, there was a procedural failing in the first tier tribunal in the Rogers and Shaw cases, which meant the case that went to the upper tribunal said, well, the revenue didn't actually get the opportunity to submit evidence to show that there was involvement of an officer. And the upper tribunal then heard evidence that said, yes, whilst a lot of the manual process is carried out by a computer, what happens nevertheless is that there is human oversight over the process. And therefore, in the Rogers and Shaw case, there was sufficient evidence to show that the notices were valid. But the Rogers and Shaw case concerned the 2015 and 16 tax year. And more importantly, the evidence that was heard by the upper tribunal in Rogers and Shaw is not binding on other cases. Taxpayers are entitled to have their cases determined by the evidence before their own tribunal. And the revenue declined to put in evidence to show human oversight over the Section 8 process in Dr. Allam's case. So the question is, there was no evidence before the tribunal to show that there was human oversight. And the revenue's argument related to the application of two statutory provisions. There was the insertion by the Finance Act 2019 of Section 12D of the TMA, which sought to remedy the situation for voluntary returns. It said, whatever is a voluntary return is now treated as a valid return. I have no problem with that. That was made retrospective. The question that was being asked in the first tier tribunal in the Allam case was the retrospection, which clearly validated retrospectively a return, did that also retrospectively validate an inquiry that had been made before Section 12D came into force? Because Section 12D refers to the validation of returns. Does it also extend to the validation of inquiries? Now, that was the first tier held that everything that flows from a return, which has now been retrospectively validated, has been retrospectively validated, therefore inquiries, conclusion notices and appeals, etc. However, because the revenue are feeling on slightly shaky ground, they also introduced yet more retrospective legislation in the following year, Section 103, Finance Act 2020. And that provides that anything done that the statute requires to be done by an officer can now be done by HMRC, including the use of computers. Now, the upper tribunal had the benefit of Section 103, which the first tier tribunal didn't have. And it recognized that if the revenue could win on Section 103, then they didn't need to consider the extent of the deeming provisions in Section 12D. So it looked at Section 103 first. And the main provisions are in subsections 1 and 3. Anything capable of being done by an Office of Revenue and Customs by virtue of a function conferred by or under an enactment may be done by HMRC. Anything done by HMRC, in accordance to subsection 1, has the same effect as if done by an officer of the Revenue and Customs. In other words, the statute requires it be done by an officer. It's now being done by HMRC, and subsection 3 says, well, that is as if it had been done by an officer. And what the upper tribunal said was, being issued by a computer, by HMRC, that's the ordinary and natural meaning of the words used in Section 103, subsection 3. The reference to HMRC in this context is plainly to HMRC as a department. And I would agree with that wholeheartedly if it were not for the fact that we also have subsection 4 that goes as follows. So it's the first bullet here. In this section, HMRC means Her Majesty's Revenue and Customs. So we can't just use the ordinary meaning of HMRC in subsection 3. We have to recognise that that term is specifically defined in subsection 4 to be Her Majesty's Revenue and Customs. Now that is a phrase that is found in what's called the schedule of the Interpretation Act of 1978. So this is a provision, such a provision that says where you see certain terms in legislation, it is to be given these meanings unless the context otherwise suggests. And the definition of the phrase Her Majesty's Revenue and Customs is expressly shown in the schedule as having the meaning given by Section 4 of the Commissioners for Revenue and Customs Act 2005. So when we see HMRC in Section 103, we know it is to be given the meaning of Her Majesty's Revenue and Customs as found in the Revenue and Customs Act of 2005. And Section 4 of that, subsection 1, says the Commissioners and the Officers of Revenue and Customs may together be referred to as Her Majesty's Revenue and Customs. In other words, what we have clearly in Section 103 is a reference to HMRC means the Commissioners and the Officers. It does not mean the computers, etc., because otherwise Parliament wouldn't have needed to define HMRC in the way it did. Now, what I'm going to do, I'm going to look at the, so I think that the upper tribunal was wrong on that point, but even if it was wrong on that point, it did go to look at Section 12D, and we'll do that next, and then I'll deal with David's question and any other questions that arise on this point in due course. So far as Section 12D is concerned, what the upper tribunal held, and consistent with the first tier tribunal, was that effectively everything that follows from the validation of the return retrospectively should follow. Therefore, there should also be a validation of the inquiries. And that's just a simple question of law as to whether or not that is an appropriate form of deeming. I think that Section 103 and the interpretation is particularly worrying, because what it is now saying is that theoretically, anything done by an officer, and for example, choosing whether or not to assess a taxpayer, and if so, how much the taxpayer should be assessed for, can now be done completely using artificial intelligence. I would say that is quite a worrying prospect, that when statute previously said it has to be done by an officer, you can now get machines issuing assessments and exercising a discretion. That is not only worrying, but it does seem to be inconsistent with what I've said is the actual definition given by Parliament to section 103. But David raises a further point. Was that human actually an officer of HMRC? How do we know the programming wasn't done by a contractor? Well, that's actually a point that arises in a case called Morano, where the tribunal assumed it must be done by someone within HMRC. But yes, the point is completely correct. At the moment, anything done by a contractor is clearly not done by an officer. However, as long as it is done on HMRC's computer, then if the upper tribunal is right in Allam, then it doesn't matter who has done the programming. But the broader point, I think, is completely correct, David. If the revenue are relying upon involvement by officers, then they need to show that the human involvement is actually by officers and not by contractors. But I suspect that if you follow the evidence given in Rogers and Allam, also Rogers and Shaw, there was sufficient evidence that there were officers overseeing the process. So even if they weren't doing the actual programming, they were acting in accordance with instructions given by HMRC officers. And David then says, I may be paranoid, but we're just wondering why that is why they've been so cagey about the off-payroll working. All sorts of possibilities. But one of the things I discovered in response to the off-payroll working is that all the programming is done by non-officers. And if you actually read the statutory accounts of the subsidiary company that HMRC set up for all their IT work, it makes it very clear that the staff of that company and the contractors of that company are not, in fact, HMRC officers. They are not civil servants. But again, it's unclear whether this case will progress to the Court of Appeal. But there is definitely something interesting about whether or not officers can now be completely moved away from the picture, and leaving aside questions as to the validity of notices, because at the end of the day, even voluntary notices are now treated as valid. Whether or not the Court of Appeal would be interested in trying to say that work done by humans has to be done by humans and has to be done by officers or commissioners of the revenue or customs. It cannot be delegated to a computer, because that I would find a very worrying prospect.